The Caribbean Court of Justice, Appellate Jurisdiction. On appeal from the Court of Appeal of Guyana. Hearing of the matter GYCV number 2 of 2025 between Eslene Vigilance and Roopnarine Persaud. The members of the hearing panel are the Honorable Mr. Justice Barrow, Presiding Judge, the Honorable Mr. Justice Jamadar, the Honorable Madam Justice Ononiwu, the Honorable Mr. Justice Ibu Usuji, and the Honorable Mr. Justice Balkan. Counsel, you may now enter your appearances.
May it please your honors. We, Taney Hoosty and Sidney Fraser, appear for the appellant in this matter.
Morning, Your Honors. Your Honor, I appear together with Mr. Mahendra Satram and Mr. Ron Motilal for the respondent.
Your honors, we appreciate the opportunity to address you this morning in support of the case for the appellant. In doing so, we repeat and rely on our submissions in support, which are found at pages 569 and 584 of the Record of Appeal, and our submissions in reply, which are found at pages 602 and 606 of the Record of Appeal. It is not intended to repeat those at all, having relied on them. But, Your Honors, we're going to embark on addressing the grounds of appeal in a manner that I would suggest is somewhat inverted. We'll start with the last set of grounds first, and then come to the procedural grounds. We have therefore separated the issues into substance and form. Substance dealing with the nature of the application for prescriptive title, and form dealing with the application for amendment, which is made before the court. By way of guidance, Your Honors, our submissions will be structured somewhat in the following manner. The substance of subtraction, the importance of a plan, a potential case for reform, the registrar's report, some additional factors, a higher duty of care in prescriptive title transports, not so bona fide, and as I indicated, the practice and procedure dealing with amendments. Your Honors, we thought that a useful starting point, though not legal, would be some mathematics. And the mathematics that we seek to deal with are cumulative and reductive. So therefore, in both dealing with the practice and procedure, there are mathematical formulas that we suggest. One addition, one subtraction, and fortunately, no multiplication or division. The numbers that provide the basis for subtraction and go to the substance of this application are 2.9134 and minus 2.9134 and minus 0.05495. I'll expand on the relevance of these numbers. Your Honors, as can be seen from pages 489 and 490 of the Record of Appeal, the transport to which, my learned friend, we'll put it up on screen. Part of the acreage of the transport in question in this appeal was voluntarily alienated in 1970 to Diamond Rush Air Wings Limited. That transport subtracted 2.934 acres from the acreage, overall acreage of the land involved. This voluntary alienation, Your Honors, we submit, prohibits any person seeking to acquire title by prescription from acquiring the whole of that property.
Who is competent to take that objection or make that point? Who is competent to do that?
It would have been an objection that would have been before the trial court in dealing with the sequencing of the movement of transports, please, Your Honors.
You have not answered my question. I need assistance.
Yes, yes, sir.
Who would have been competent to take an objection that land already transported is now being prescribed? Who would have been competent to take that objection?
Two parties would have been competent to take that objection, please, Your Honor.
Right.
One, the person who, in this case, Diamond Rush Air Wings, they would have had an opportunity to file an opposition had they, that is one.
Right.
And two.
Say the person who is the beneficiary of the alienation.
Yes, please, Your Honor. Yes, I acknowledge that. Yes, that's one. And also, they've had the opportunity, and this is part of what they're contending, that the application that was before the prescriptive title application went for the entire land.
Right.
But during the time when this person, the Estrich, suggested that he was in adverse possession of the whole, there was a voluntary alienation by the person whose title he seeks to extinguish.
Right, but this is it. We are in a court of law, and this is why I'm trying to get standing and capacity to make objections. The man on the street can't simply come in and say, hey, hold on. It sell a piece of that land already, right?
But it is the owner of the land who is indicating to the court that you can't take all of my land because I already gave it to someone.
Then, Mr. Host, you just said the owner of the land says I already gave a piece to somebody.
Yes, please. Your
So having given that piece to somebody, the quote owner of the land is no longer the owner of the land.
Correct, Your Honor.
Yeah. So Diamond Rush did not give any power of attorney, any authorization to vigilance to say, protest.
Correct.
Yeah, so then, no standing. I'm just...
For that, no, I'm just Your Honor, the reason why I'm pointing it out is the subsequent movement of the title still includes the whole.
Yeah. I know what you are seeking to do.
Yes, please.
You are seeking to establish that there were irregularities, there were things which ought not to have been done, the land court did not pick this up, etc., etc. Protests were not made. We understand all of that, as you say. You will not recite your entire submissions to us because they are there and you trust us to have read them. Therefore, why are you taking us through this?
Merely to say, please, Your Honors, that when one looks at the tracing of the title, it highlights this. And these irregularities, these cumulative irregularities.
Mr. Hootie, can I?
Yes, please, sir.
So the title is claimed by possession, correct?
So, yes,
Yeah.
for all intents, for argument, yes,
Yeah.
as the record stands, yes, please, Your Honor.
Yeah.
Yes.
To claim possession, you have to notify current owners. I just want to flip what you're trying to do the opposite way.
Yes, please, sir.
Possession is adverse to whoever is the owner. Agreed?
Yes, Your Honor.
So a person comes and say, I've been in occupation of lands, wherever they are, and you describe them, and you come for prescriptive title. Yes?
Yes, please, sir.
In this case, they came for prescriptive title of all of Lot 4. Agreed?
Yes, sir.
Parts of Lot 4 had been, as you say, voluntarily alienated.
Yes, please, sir.
Yes. In the application for prescriptive title, were all of the owners duly notified because the application has to go through a process, is that right? You have to
Yes,
do-
please, Your Honor.
right. So was there compliance with the statutory requirements by a person claiming adverse possession to land in relation to owners and neighbors?
Our examination of the record, and I know my learned friend will pull it up for this honorable court. No, there was not.
Mr. Hootie,
Yes, sir.
is it competent for you at this stage to say that the land court, which should have satisfied itself of that, did not satisfy itself of that? I'm serious. Is it competent?
Insofar, yes, please, Your Honors.
Really? Okay.
Because and the reason why I'm saying that is because we're dealing with a title before this honorable court that has its root from that. And it is the cumulative effect of the defects that we're seeking to.
As a matter of the practice of law, to do what you purport to do. You want to impeach the prescriptive title. We are very clear on that. You brought a case, or your clients brought a case against the Estrich and Persaud in which that application was made. It failed. There was no appeal against that failure in relation to the Estrichs. The judgment in favor of the Estrichs, in which there was a refusal to give any determination that they wrongfully obtained or wrongly or irregularly obtained prescriptive title, that judgment stands in their favor. It was not appealed. I have, as you will appreciate, the greatest difficulty in understanding what enables you, what permits you to now impeach that determination.
The basis upon which we are seeking to do that, please, sir, is because of the nature of or the connected nature of Mr. Persaud's title to.
Mr. Hootie, please be kind to me. Take it that I know that,
Yes, please, sir.
and take it that what I'm saying to you is you are seeking to impeach Persaud's title by impeaching first the root of that title, which is the title in favor of the Estrichs. And what I'm asking you is what entitles you, not why, you know, but what entitles you to impeach Estrich's title at this stage when the trial court found in favor of the validity implicitly of Estrich's title. The trial court refused to impeach, to impugn Estrich's title. How are you entitled? How should we allow you to proceed by seeking at this stage, when the Estrichs are not before us, when there is no appeal against that determination in their favor? What enables you to do what you dearly want to do?
Your Honor, the issues were live before the trial judge. The issues form part of the decision of the Court of Appeal.
No. Stop right there. it did not form part of the decision of the Court of Appeal because the determination in favor of the Estrichs was not appealed to the Court of Appeal.
Well,
I looked at the record, Mr. Host. You must appreciate that we prepare very fully, expecting the scintillating advocacy by such as yourself.
Your Honors, the way that could have been permitted, Your Honors.
Been permitted where? At the Court of Appeal?
No, the way that it could have been permitted in the first place, we contend would have been for the amendment to have been granted to the statement of claim, to allow those issues as they emerged before the trial court to be part of the record.
Mr. Hoste, you really are exhausting me. I'll turn over to my brother.
So,
Perhaps
Mr.
he can
Susi, yeah, the amendment that this appeal before us is about a refusal around an amendment. Agreed?
Yes, please, Your Honor.
All right, so let's try and approach the same question from a slightly different point of view.
Yes, please.
This amendment that you were seeking, what did you want to achieve with this amendment?
Your Honor, what we would have wanted to have achieved in the amendment, and I will...
No, let's just try
No,
and
no, no,
stay
I
on
will
track.
answer. No, I just...
The chair is going to get impatient if
No,
we go
sorry.
off track.
Sorry, no. More impatient.
Well, Your Honors, what we would have hoped to have achieved by the amendment would have been an expansion on paragraph 6 of the statement of claim, which dealt with the allegation of fraud, but the absence of particulars. So paragraphs...
Fraud, all right, so let's stay with that.
Yes, please, Your
Let's
Honor.
see. Fraud to what end? Because you pleaded fraud, didn't you?
Yes, please, Your Honor.
What was the target of the fraud?
There would have been the target of the fraud that was identified, and the statement of claim is at page 406 of the record of appeal. The target of the fraud, yes, Your Honor, the target of the fraud would have been, started out to be, the transport of the Estrichs. That is where that started out. The way that the case evolved through the evidence was that there needed to be an extended target or an added target to the particulars of fraud.
Which was?
Mr. Roopnarine Persaud. Specifically, you see, Your Honor, we acknowledge the defect in the...
Mr. Hoste,
Yes, please,
I
sir.
think you're being very unkind to us. You pleaded fraud against Estrich. The particulars that you were seeking or that you could have sought would have been really in relation to making a claim of fraud against Persaud. You did not claim fraud against Persaud.
Your Honors, we acknowledge...
So then you can't get particulars of fraud against Persaud by altering the particulars in relation to the Estrichs.
Your Honor, Your Honors, correct. The point that paragraph 6 of the statement of claim speaks to Estrich's fraud. When we turn to paragraph 8, there is a paragraph 7, sir, Your Honors. There's a purported sale mentioned in paragraph 7 to the third named defendant.
Right.
What the evidence revealed is the nature and the potential privy of the third named defendant to this fraud. And, Your Honors, if you look at the evidence of Persaud, when he said that he knew, he said in his evidence on the cross-examination, I think it is at page 237 of the record of appeal, I knew that Estrich was applying for title by prescriptive title.
Yeah.
Hence, there is if Estrich himself and Estrich's application was tainted by fraud, Your Honors, our contention is that that subtle line extended and began the taint of Persaud to the fraud.
Mr. Huste, you would have needed to say that Persaud was privy and had full knowledge of the aforementioned fraud on the part of Estrich, and that knowledge is contained in the following particulars.
Right,
You did not do that, so you needed to bring a case of fraud against Persaud. You did not do it, Mr.
Well, it was not done. That is quite correct, Your Honors, and that is why the amendment.
But you could not get an amendment to file particulars when there is not any allegation of fraud in favor of which particulars can go to support.
At the time, Your Honor, the fraud we contend emerged in the course of the evidence. And it is in that context. Yes, please, sir.
Help me understand something. So all the evidence you needed to establish a fraud against Persaud came out in the case.
Yes, please, sir. And Your Honors,
And hold on.
sorry.
Were you allowed to make submissions on it?
Your Honors, no.
No. Because you had not, you tried, I suppose. Because remember, you come for the amendment at the date of delivery of judgment. So the fraud against Persaud comes out in the evidence. Agreed?
Yes.
All right. Then you make submissions to the trial judge. You make submissions.
Submissions were made, yes.
Right. So did you, in your submissions, at that opportunity, did you try to make this connection that you're arguing for now?
Your Honor, our contention is...
Did you try to make the connection, i.e. to say exactly when?
It was not attempted.
No. Okay. So you closed off your arguments, never raising that.
At the time.
Yes.
Correct.
Yes,
Your Honor. Yes,
the
Your Honor.
submissions, right. At the end of the hearing, how long before the judgment?
Your Honors,
4 months, I think it was. What was it? I can't remember. How long was it? A few months, right?
Potentially,
Yeah.
please, Your
At
Honors.
any point in time between then and the date of the hearing, did it occur to you that, look, this evidence came out, this goes to fraud, this should be raised?
Your Honor, I am somewhat at a disadvantage. As you said, you.
Well, okay. The attorneys.
Right, exactly. So, Your Honor, clearly, it was not until that time that it came,
That time?
before the decision.
The day of the decision?
Yes. That is when it is articulated, Your Honor. I can only go on the basis of, yes, please, Your Honor.
And was something formulated? Was notice given to the other side? Was notice given to the judge? A call, a letter saying, look, on reflection, we have discovered this evidence. We think this is important. We know it's late in the day. We want to make an application. Or did you just stand up when the judge came in court to give the decision to say you want an adjournment?
I would, based on the record, I would have to say that would have been the sequence of events.
Yeah.
Sorry, did you ask for it? I'm very concerned. Did you ask for an adjournment?
Your Honors,
Did anyone ask for an adjournment on behalf of Vigilance?
I would have to check Your Honor, if it's not reflected on the record, I will have to go by the record.
There is not any application for an adjournment on the record. Because, Mr. Huste, amendment, further evidence, for those orders to be granted, they could only be granted on the basis that the judgment scheduled for delivery on that date would be withheld and the case would be adjourned. I don't think anybody had the effrontery to seek an adjournment explicitly.
And, Your Honors, if one were therefore to look at the circumstances, the application was made, according to the record, orally. The court, in considering that application, now, we all have responsibilities and accountability in this particular system. The court, in dealing with its responsibility, said, oh, you're too late, there may be some prejudice. Your Honors?
Was the application made in a form that articulated grounds or gave some, or was it just, I want to amend? How specific, how structured was it from the record? How would you describe that?
Your Honors, I describe it as a situation where...
No, I'm talking about the record.
No, the record says, Your Honors, based on the record, may it please Your Honor, I just figured out that I need to make an amendment to the pleadings.
Would you describe that as rather cavalier at that point in time? So when was it just figured out? Was it when the person was sitting at the bar table? Was it because if I were an attorney and I figured that out, I know judgment is tomorrow, and I figured that out last night, I wouldn't have slept for the night. I would have called my juniors or my clerks out, and I would have been trying to prepare some papers, something. So there is an element in this that what did you expect the judge to do with such a cavalier?
See, this is exactly the point, Mr. Houston. You needed an adjournment, and you did not ask for it. I want to tell you that I will trust you in the course of the balance of your address to persuade me not to go down the preliminary path of thinking this was an abuse of the process of the court. I have not decided it is. I will trust you to steer me away from that path. Okay?
Thank you, Your
So
Honor.
you have the rest of your address.
Thank you, Your Honor.
Good.
The concept in this particular instance of the abuse of the process of the court has to be examined from the part and the extent of the responsibility of the litigant herself and the responsibility of counsel. In this particular instance, please, Your Honors, the litigant cannot be faulted. She pursued her case, and my learned friend even identified situations where the litigant even cross-examined, attempted cross-examination in the absence of counsel. The case that we're dealing with, please, Your Honor, is in relation to the litigant. And this litigant consistently pursued her case before the court. Counsel, the voice of the litigant, may have faltered in the way in which that matter would have been communicated. Your brother, Justice Jamadar, mentioned the responsibility and duty of counsel. Your Honors, this morning, preparing for this case, I saw that the title of Persaud didn't even have the acreage. We are caught with times as counsel when we need to do that is the 3 o'clock in the morning decision that we make. But in this particular instance, Your Honors, the amendment was for the purposes of the litigant, not, the litigant fell for that, but the litigant was not the person who did not pursue the case. Your Honors, that is why it is not an abuse of the process of the court. This is during the pursuit of a case for several years, and the litigant did not falter in her pursuit of this case. And that is why it's not an abuse. And it's the evidence that revealed itself over the years during which yes? Your Honors,
is not to reopen and lead any new. You have no smoking gun to produce. What you want is to, based on the evidence that was elicited, to simply make an allegation of fraud against Persaud, which was not pleaded, to try and show that the prescriptive title should be vitiated on the basis of fraud. Is that what you want to do?
Yes, please, Your Honor. I cannot. Yes, yes, yes.
Yeah, Mr. Hussey, did you itemize anywhere what's the nature of the amendment you want to make and the details?
No, please, Your Honor. It was not. The opportunity
It wasn't done then, and it hasn't been done up until this point.
Correct, please, Your Honor. Your Honor. Well, Your Honor, I can.
Argument. If you are coming to tell us that this is going to be, yours is a...
I'm making the same mistake that counsel made
You
before.
are coming to us to tell, clearly, this is late in the day, probably too late. So you're coming to say, listen, grant this indulgence. Why? Because if you do, the court can right a wrong that is clear on the record. Correct? That has to be
Yes.
what you believe.
Yes, Your Honor.
Well, and you have not in your submissions even said to us, look, the judge went wrong, Court of Appeal went wrong, we want you to go right. What we want you to grant, because you have the record, is amendments saying A, B, C, and D, because this will establish D, E, and F, which would have a realistic prospect or would be conclusive about so and so. So, what do you want us to do?
Would you give me an opportunity to do so?
Well, now you sounded, you want an adjournment. Well, you deal with that with the president.
Well, Your Honor, no. But Your Honor, I acknowledge that sorry, Your Honor.
Counsel, on the same train, I know you've had a difficult exchange this morning, but I'm trying to be gentle here. When I read your reply to the respondent's response, and to your reply rather, to see whether you dealt with that, is it fair to say you didn't, even then?
Correct, Your Honor, because we did not. Correct, that is correct. That is quite correct. Because it is on the record of itself.
You could have said that in your reply and pointed that part of the record to say submissions of the respondents were misguided because here, and there in the record are the materials that show the fraud you're trying to plead.
And I can do so even now because the record is before this honorable court.
Can you?
Yes.
Proceed.
One first factor that we point to, Your Honor, is the absence of, well, I will not go back to the numerical subtractions. The absence of a current plan.
Has that evidence of fraud?
In this instance, we would suggest it is part. The fraud is cumulative. Your Honor, if you look back to... Yes, please, Your Honor.
Mr. Hussey, answer my brother. Particulars of
Yes,
fraud.
sir.
Don't tell us something is wrong.
I'm going to that, please, sir. My apologies. I just needed to find...
I have absence of current plan.
That is
That
one.
is a particular, one
That
of the
would-
particulars of fraud.
Part of it.
Continue. Two,
Your Honor, Persaud's acknowledgement that he was aware that Persaud's awareness of Estrich's prescriptive title application and the defects contained therein. Expanding on that, Your Honors, we have a defective registrar's report, which is found at page 276, I think, of the record.
don't go to it, don't bother.
Okay. We have the following sequencing as well. Your Honors, At page 4375 of the Record of Appeal, we see that the order for prescriptive was granted on the 12th of April. The plan,
Mr. Hootie, pause. You say an absence of a current plan. Now, I understand how this thing happens. Have you produced a plan that you say there's an absence of something? Have you produced a plan to say that this is what a current plan would have shown in relation to occupation? Because this is a case about proof of occupation. You want to say something about occupation. You criticize the absence of a plan. Fair enough. On the face of it, that sounds very important. But would it have made a difference, such a difference that we could conclude, based on a contemporaneous current plan, that the order is fraught? In other words, the order giving possession of 4 acres is fraught because this is a contemporaneous plan. Look at what it shows. If anything, the occupation was of 2 lots, whatever, but certainly not of the lot 4.
the fact that...
Have you produced such a plan?
No, Your Honors, we have not produced such a plan.
May I help you? Let me stop you, because I want to give you the chance to complete your particulars. You have given us 4.
Right,
Would you like me to read them back to you, or you seize of them?
I have a
So number 5.
annotation. Your Honor, and this is the privy to the fraud. On the 13th of April, 1994, a 1962 plan is deposited in the deeds registry as the current plan, when that plan, that 1962 plan, has already had at least 2 extractions made from it. On the 3rd of May, Persaud acquires transport. The transport of Estrich is listed as the 3rd of May, 1994. And on the 16th of June, 1994, there's an agreement of sale for this.
So what date? Agreement of sale?
16th of June, 1994, and that is found at page...
It doesn't matter.
Okay, sorry, please, Your Honor. It's 498 of the Record of
Agreement
Appeal.
for sale.
Your Honors, when we look at the transport of Persaud, there is no mention of the acreage in the description of the transport.
Yeah, that's it?
And it is from that... Yes, please, Your Honors.
Okay. I can see why you did not want to particularize these before in the court. I can tell you, if I were a judge, I would say you're wasting my time. But that's just me.
But, Your Honors...
My sister and brothers may be more kindly.
Counsel, all that material you just mentioned now, were they always on the record of a trial?
Yes, please, Your Honor. Further, Your Honors, yes, please, Your Honors. I'm not. Your Honors, the case, as this court correctly notes, is what was... I cannot bring any... It was what was before the court at the time. I cannot, in 2025, suggest that these are considerations which this honorable court ought to take.
So the question then, the reason I asked that
Yes, please, Your Honor.
question, so your request or your predecessor in office's request at the time on the day of judgment for an adjournment, to amend the pleadings, wasn't really to lead new evidence, because you're saying the evidence was already there on the record. Is that correct?
Yes, please, Your Honors. I could not envisage any...
Yes, please.
Your
There was no new evidence to be called. Is that the point?
Your Honor,
Because my question to you
I understand, Your Honor.
okay, so this material were always on the record of a trial judge. Is that correct?
yes, please, Your Honor.
And the application then wasn't about leading new evidence. Is that correct?
Yes, Your Honor.
Okay. And then the trial judge's dismissal of the case of fraud was not merely because it wasn't pleaded. The trial judge went further to make findings that fraud was not established in the case. How can you help us see how we should overrule that factual finding?
Your Honor, it's an interesting situation.
Mr. C, sorry to interrupt
please, Your
you,
Honor.
but could I just add to that question? So we all have this understanding now that this evidence you say was already there, it had emerged. So I presume the application was to bring the pleadings in line with the evidence. This not having been done, and we're now at this stage in 2025, my question is, and this is partly my lack of clarity as to whether you are contesting the transport to the Persauds or the transport to Estrich on the basis of the initial prescriptive title. So I guess my question would be, if we seem to be going back to that, the initial conveyance, the prescriptive title process that led to a transport to Estrich, are you saying that we can properly revisit that in this appeal when the Estrichs are not a party, never were, both at the Court of Appeal and here?
Yes, very cautiously, please, Your Honors. Very cautiously. Because it is the revelation of that underlying nullity in the transport of the Estrichs, we suggest that gives this court an opportunity to examine that and at least examine the nature of Persaud's transport, Your Honors. Your Honors, as I said, this morning is the first time I realized that there was no acreage described in Persaud's transport. There's absolutely none.
And you think that is fascinating and earth-shattering?
Not quite earth-shattering, please, Your Honor, but it
close
is an
enough?
addition. Sorry?
Close enough? A little
No, please, Your Honor. It's because it's worthy of note when one looks at the cumulative actions that would have led to that
But
transport.
you see, you are alleging fraud, eh? So you remember, what you're trying to do is, who you're trying to, let me just be 100% clear. Who you trying to allege fraud? This amendment is alleged fraud against who?
Persaud
Good, so
as
let's
being
just stop.
privy, yes.
The absence of a current plan. Defective registrar's report. Does a defective registrar's report ascribe in any way fraud to Persaud?
No.
The 1994 agreement for sale. How does it ascribe fraud to Persaud?
Is the timing of the agreement of sale makes him privy to Estrich's fraud because he was aware, according to his own evidence, that he was purchasing the property from Estrich, who was making a prescriptive
So
type
when you asked him about that, remember you're trying to bring this in line with the evidence. So what was his evidence? Was that put to him? That you were aware and having that knowledge, you went ahead and therefore you were fraudulent. Was that put to him in cross-examination?
No, please, Your Honor,
So
from
if
my
it was
recollection.
not put to him and you were amending this to bring it in line with the evidence, suppose we allow you to put as a particular, the agreement for sale, as you say. What submission can you make? You cannot submit what you just said because Persaud never had an opportunity to be confronted with that and to answer.
Well, Your Honors.
Is it that you're going to tell a court, draw an inference that he was fraudulent when he never had an
No,
opportunity?
no, Your Honor.
So where's that going to take us?
It will take us in the direction of giving Persaud an opportunity.
No, remember, we're not going back into the evidence. Remember, you told our brother, you told me, this is not about opening the case. This is not about new evidence. This was an opportunity you wanted, you said, on the existing evidence, to bring the pleadings in line, to allege fraud against Persaud, because you felt if you could win. Now, our chair has asked you particularize. You particularize. Now that you particularize, the interrogation is, how could this help you on the evidence? Sorry?
Your Honor, I would have to...
Of fraud against Persaud. That's why you want to do this.
Well, Your Honor, insofar as the allegation was not put to Persaud, it may be a situation where he would have to respond to the particulars as
But
provided.
therefore, you want to reopen the case and recall a witness and put your case to the witness.
Your Honor, I will therefore, with this direction, I will have to withdraw my earlier suggestion or conclusion that,
You know what troubles me?
please, Your Honor.
We are asking you these questions. You have control of your case. We asked you, what is this about? Do you need to know? I don't need to reopen, no new evidence. I just want to bring it in line because if I had that opportunity, I can show fraud on the evidence. Because you remember you told us the attorney did not raise it. You had an afterthought or a late thought, not you, on the day of the thing, and you want the chance. We are interrogating, giving you the chance. But then when we interrogate further and we ask, can the evidence support it? Now you're going to say, well, on further reflection, what I now need is something different. Well, you're
Your
moving
Honor,
the goalposts on us.
no, my apologies if it appears that way. Your Honor, the amendment could not have been granted without giving the defendant. So I made a premature conclusion, Your Honor, because my conclusion was without the response of the respondent to the application for the amendment. So I was just, if particulars are put in, they would have an opportunity to respond. Would they capitulate and said yes? Hopefully.
Mr. Hoste?
Yes, please,
You
Your Honor.
have 10 minutes remaining.
Yes, please, Your Honor.
Use it to your best advantage.
Your Honor, the awareness of this honorable court of the facts allows us to, and this is where I acknowledge that as counsel,
If he wants to.
Your Honors,
Go ahead.
as counsel representing parties before a court, one has an opportunity to articulate certain points that do not necessarily accord with legal authority. And it is with this opportunity that I endorse, well, I share some words and share some perspectives that have been provided to me by my clients, who are the ultimate victims. I myself have used 3 words, lest we forget. And Your Honor knows the types of activities or actions to which those were what prompts these words. And for us, at this particular instance, our clients are the victims of a system. So they ask the following as the victims. One, when the system fails, should the state compensate a party as a constitutional deprivation of property? They're missing records. Should provisions be put in place for the records to be digitized so that the system of itself is strengthened?
But the state
Should-
isn't a party
yes.
to this, Mr. Husti.
Sorry?
The state isn't a party to this.
No, I understand. No,
I'm not
no,
sure if you're asking this for us for an order.
No, Your Honor, I cannot. It would be unfair if to use that word or improper. But this is the sentiments of the appellants that I'm expressing with the opportunity that has been provided by the court. Should these archaic rules, should a court be allowed to say, as the Court of Appeals said, there is no requirement for a current plan when adverse possession is a matter of fact, Your Honors?
Mr. Huste,
Yes.
my brother told you that the purpose of the plan is not to document the adverse what are in issue.
Yeah, Your Honors, Your Honor, as I said, with the opportunity provided by this honorable court, I'm echoing or seeking to echo, as requested, what the client feels. We acknowledge the limitations, but there's an opportunity, please, Your Honors. An opportunity is to strengthen the system so that something like this, these errors like this, should not happen again. And it's a responsibility. Yes, please, Your Honor.
Mr. Host, does the Bar Association, the legal profession have a role to play in that sort of reform you're talking about?
Your Honor, Your Honor, there are multiple stakeholders that have a role to play in that reform. And if I take off for a moment, take a step back, and then take a step forward, I'm a member of the Law Reform Commission in Guyana. This is something that has to go on its agenda because it is the archaic nature of our system that continues to harm and deprive persons of their rights. Your Honors,
Mr. Huji, we are not a commission of inquiry.
I know.
We're a court of law deciding an appeal. So there may be a lot of merit in everything you say, but you're choosing to use your 10 minutes this way. I think you've probably used 8.
Your Honors.
And Mr. Huste,
Yes, please,
I think
Your
in fairness to the Caribbean Court of Justice, and in particular without being invidious to my brother on my right, you would have read Todd and Price, you would have read the other cases in which this court made strong pleas for reform of this very system. So please, when you tell us what troubles your client, bear in mind that there is not any need for it. We are well seized.
And that is why I thought it appropriate. Now, Your Honors, one of your brothers once told me, not because the court gives you a full hour, a full 10 minutes, you must use it all.
That sounds like a familiar utterance.
Yes, please, Your Honors. And if I cannot be of any further assistance, myself and my junior, we thank you for this opportunity to address this honorable court on this pressing issue. And we hope that remedial justice shines its light in favor of our clients.
Thank you very much, Counsel. At this juncture, we propose to take a 20-minute break, and we shall return thereafter. Yes, shall we resume? Counsel?
Now, on the very last page of, yes,
Before you go in,
yes,
before you go into that point, and
Yes.
I am not distracting you at all from
yes,
it,
please.
I would just like, as a matter of perspective, why were the submissions for this vigilance filed that date? And I see it was in 2009 that submissions for Persaud were filed.
Well, they're definitely late, but I don't know why they were late, and there is no explanation in the submissions themselves.
But not just late, but the order. Vigilance was the plaintiff or claimant.
Well, in Guyana, the practice is, as far as I know, is that the defendant goes first.
I'm guided.
Yes, please.
Mr. Satram, on a more minor point, just as a matter of form, usually advocate appearing before the court, conventionally they wear bands.
Yes.
Just for your information. Yeah, so, but we see you and we will hear you.
Again, in the practice in Guyana, I think no one really wears bands in Guyana.
Is that right?
Yes.
All right, well then maybe that is a fine practice before us.
It's
I withdraw
a
my
change we
comment.
brought about after we abolished the Privy Council. Your Honor.
Yeah, good.
Isn't Mr. Hustif from Guyana? He's wearing bands.
Yes, Your Honor. But
You said
generally,
no, you
we
said
don't.
no one wears bands anymore.
Hardly, yes. If at all. Now, Your Honor, at page 287 of the record, the submissions of Mr. Moore that went in the day before judgment was set to be delivered, it is submitted there that the court, this is third to last paragraph, the court will be asked to allow vigilance the opportunity to produce documentary evidence on the parts of the land sold off by Albert Vigilance, as annotated on the transport, and of the payment of rates and taxes by Mrs. Vigilance. It goes on further to say, a summons is about to be filed for the Commission of the Inland Revenue to verify that no compliance was regularly issued by his department for the conveyance from Estrich to Persaud. That there, Your Honor, seems to me to capture what the amendments related to. Now, the first one is the opportunity to produce documentary evidence of the parts of the land sold. That documentary evidence was already part of the record. Your Honor, we'll see two transports. One in the
Mr.
name.
Satram?
Yes, please.
I'm just curious. Given that we have a full plenitude in this court
Yes, please.
as to what was sought, what would ideally have been the amendments, the particulars, do you really need to go into any aspect of it? Do you think that any of those particulars would go to support a case of fraud against either Estrich or Persaud?
Yeah, no, not at all, Your Honor.
So I'm just wondering,
Yes.
whether it is a matter of completeness,
Yes.
which makes you embark on this.
Yes, the only reason why I'm raising it, Your Honor, is because there were questions coming to the bench as it relates to what were the amendments. And all we have on the record is what is contained in the submission of the plaintiff in the court below. And as far as the record is concerned, at least two, the transports were already on the record. Your Honors will see the transport in the name of Diamond Rush and the other in the name of Fleming. as it relates to the rates and taxes, there is no indication as to when it was paid and so on. And the final point, as it relates to the summons to be issued to the commissioner with respect to the compliance, I just wish to point out to the court that the issue of the missing compliance arose in cross-examination of the registrar at pages 247 and 248 of the record. There was a suggestion by counsel, I think in April of 2009 it may have been, that there was no certificate of compliance. And the point I wish to make is that it was known since then that the compliance was missing, yet no subpoena or summons was issued. So these are not really new matters, so to speak. The transports are already on record, and the issue of compliance came up in cross-examination. It's not something that they discovered just before the 10th of July, 2010. Unless there is there anything in particular that Your Honors would like to hear?
Counsel, I just have some questions relating to the grounds of appeal that relate to irregularities.
Yes.
In the process by which title would have passed. So most of the submissions that we would have heard from the appellant earlier on concerned the application to amend, to introduce particulars of fraud. But there are a number of grounds of appeal. I'm looking at the notice of appeal here that really are directed at alleged irregularities that were so significant that they should have led the trial judge to arrive at a different conclusion. I am going to ask you to respond, please, quite directly to some of them. I've looked at the submissions of the respondent, but I just want to ensure that you respond fully to particular submissions that would have been made by the appellant. We did discuss earlier the question of the relevance of an up-to-date plan. I've seen that in your submissions, you've addressed that. How do you respond to the particular allegation relating to the non-recognition or the alleged non-recognition of the voluntary disposition of certain parts of the land that would have been acquired by prescription?
Well, there is on the record an affidavit of service at page 493 of the record, issued in the name of a Linton Esmond Fleming. So that owner was served with the proceedings and took no part in the proceedings. The affidavit of service is at page 460, and the transport of Fleming is at 493. And there's been no participation or no objection raised by any of the three persons who got title from Mr. Albert Vigilance prior to his death.
Yeah, Mr. Satram, I'm not sure that that's exactly how I understand the question.
Yes, please.
So it's not about whether they appeared or not.
Yeah.
Or even to me, and if I might just tweak my sister's question a bit, not even about perhaps this disposition or the plan, but this cumulative set of circumstances around that process, which is part of the second round of appeal, which is what my sister is asking you. But I think my concern is, how do you respond to this ground, which alleges that cumulatively there were a number of irregularities in this original process, this route of title, so to speak, that led to a transport to the Estrich. Well,
But the
so let me put
case-
it a little more plainly then. Did the trial judge assess this properly?
I think so, Your Honor.
And
because
why? Why not?
the case as presented, the submissions are on file. I just referred Your Honor to it. And the cross-examination was focused, I believe, on 4 things. 1, the absence of a recent plan. 2, the non-service of the petition on the adjoining landowners. 3, the fact that the Estrichs were fictitious persons. And 4, as far as possession is concerned. The main points that were advanced by the plaintiff in the trial court. There was, of course, the allegation which came in the 1999 action after Persaud obtained transport in 1996, which alleged that the transport which Persaud obtained was not obtained in a regular manner, or a regular process, as they say. Now, I can take them in turn, Your Honors. With respect to the recent plan, there is no such requirement on it.
In the rules.
Yeah.
But this is a judicial process, yes?
Yes.
And you have to examine the strength of a claim that I have been in possession, I have been using this, occupying it, whatever. And so, quite apart from the strict legality of a recent plan, does the absence of this have any impact on your claim of use and possession and occupation?
Well, in our submission,
Mind
Yeah.
that in 1994, we have the evidence on record that this place was overgrown. There's no evidence of any kind of occupation. And this is from several parties on both sides.
yes. Well, the plan by itself cannot or does not prove possession. Possession can be established by other evidence. The plan is really drawn by the surveyor, and it gives his impression of the state of the land at the time the plan is prepared. As Your Honors know, the petition is required to prove 12 years possession. In this case, the petition alleged that adverse possession commenced in 1970, long before the respondent and the others acting on his behalf visited the land in 1994. So, as far as, the recent plan can only prove what was the state of the land at the time the plan was prepared, if at all. But the rule, the Declaration of Title rules is clear. It says, Rule 3.3 says, a plan of the property shall be annexed to the petition. And that was done. Your Honors will see that a plan was laid over, simply defining the boundaries of the land being claimed at page 453 of the record. There's an entry there which suggests that the plan was laid over. As regards service of the adjoining landowners, there is an affidavit of service I just referred Your Honors to at page 459 and 460. As regards the non-existence of the Estrichs, there are a number of sworn documents, Your Honors, deposed before different commissioners of oaths, before different notaries. There is a power of attorney and record at page 473 from George to Leon Estrich. There is the evidence of Mr. Punai, senior counsel, that he represented Estrich in court. There's the evidence of the registrar confirming the appearance of Leon Estrich before her. And there's also something which has not been pointed out, an affidavit in support of the petition given by a vigilance, Vivian Vigilance, at page 458 of the record.
Possession of the whole becomes a questionable document. If, in the meantime, subplots had been allotted to other people.
You see, Your Honor, when lands are carved out of a larger area and sold, as in this case, the sale is annotated on the transport. So it is no secret that these portions were sold does not mean that George Estrich could not have been in adverse possession of those portions. And that is the determination the land court judge made. Because he went to the land court on a petition saying that I'm in possession of this particular piece of land as laid down in this plan, which I'm laying over. The transport for the land reflected that 3 portions of it were.
Make pronouncements as to that.
There's no written judgment as far as I know, Your Honor. All we have is.
Were those documents available?
Yes. The petition it starts at page 453 of the record. The petition starts at page 453. Because the issue before the land court judge was possession. A man can be in possession of lands covered by 100 transports. It doesn't matter, and claim prescription in respect of all of them. In this case, as I said, it was known that portions of the land were sold, and there was to the satisfaction of the land court judge.
So here we are now, the pronouncements or the findings or judgment of the land court judge is not, could not be found. If I understand your submission. 1 second, please. And appellants have also alleged that part of the difficulty with the regularity of title has to do with a trail, quote unquote, a trail of missing pages at the land registry. Now, all those plus other allegations about irregularity, would that not raise questions about the bona fides of anyone who claims to be an innocent purchaser for value without notice? Can you, point is, can you willfully be blind?
Though there was a clear finding by the trial judge that Persaud was not privy to any fraud and that he had no knowledge of any fraud. There was a clear finding to that effect.
Could he have him put on his inquiry?
I didn't get that, please.
Could he have him put upon his inquiry,
but inquiry,
even though he may not have been privy?
Well, his evidence, which was accepted by the trial judge, Persaud's evidence, the respondent's evidence, is that he was introduced to the land by a real estate agent. He visited the land. He saw a copy of the vendor's transport. He entered into an agreement of sale and purchase. He paid consideration. He retained a lawyer to effect the conveyance. The conveyance was gazetted. He attended transport court, appeared before the registrar of deeds. Leon Estrich was there as the attorney of George Estrich, and a transport was issued to him on January 1996. and he denied having any knowledge of any fraud or irregularity. And those questions were put to him directly in cross-examination. Remember, Your Honor, the purchaser, does not control the process which results in the issuance of a transport. If they could not be found subsequently, the evidence of the registrar was not rejected. The evidence of Mr. Punai, senior counsel, who represented him, was not rejected. And the judge found that he was not, even though there was no allegation that he committed fraud in these proceedings, the judge found that he was not involved in any fraud or privy to any fraud, and that the transport was properly issued to him. I mean, I can take Your Honor to those findings if you wish. But the judge...
Mr. Setram?
Sorry, Your Honor.
The issuing of prescriptive title to the Estrich, or to Mr. Estrich, was that a judicial determination?
Yes, please, Your Honor. The transport, as Your Honors well know, can be obtained through a private arrangement where people simply buy and sell, or as in this case, it can be obtained by a declaration of title through a petition presented to the land court.
And when that declaration is granted, it is the court which determines that
Possession.
your petition shall be granted and you shall have title. Is that
Yes.
correct?
It's
Thank
a
you.
judicial determination.
Thank you.
If the petition is not opposed, as in this case, and someone feels that a fraud was committed on the court, on the land court, the way we deal with that is that we bring fresh proceedings in the High Court to set aside the judgment of the land court. And that was one of the problems the trial judge had with this case. There was no order to set aside the decision of the land court judge.
But Mr. Satram, wasn't the 3904 the action?
Yes.
I mean, this sort of declaration that actually went straight to that obtaining of title by the Estriches, right? So it spoke to lots 3 and 4, that it was obtained by fraud. And there was a claim that he obtained, this is the first defendant,
Yes.
obtained title by fraud. So this was in essence challenging that process, was it not?
Well, the relief sought at page 407 of the record, this is a statement of claim I'm looking at. It says A, 13A, page 407, Your Honor. There was no direct challenge to the order of the land court, not in this or any of the other
But
cases.
I don't quite follow. You don't, what would be the effect if that was successful? If that claim was successful, what would have been the effect?
Well, this, Your Honor, is a challenge to the agreement, because when this action...
If the claim had succeeded,
Yeah.
what orders were prayed for?
Let me just add to that,
Yeah.
because 13F says any further or other reliefs as the court thinks just. So wouldn't that have covered what's already, endorsed on the writ? Or,
The point is, maybe by, as you say, in the land court, if there is an opposition, if it is opposed, you have a right of appeal. If it is not opposed, you have to come to the High Court to challenge it by way of petition on the basis of fraud. Is that right?
Yes, please, Your Honor.
Right. To set it aside. What are you setting aside? The transport issued by the land court.
Yes.
Right. What was this claim about?
If the judgment or order of the land court is successfully challenged, it results in consequentially, the transport would go.
Exactly.
But in this case, and this is the way the trial judge approached the matter.
No. Before we reach how the trial judge approached it, the interrogation is as to whether or not the challenge in the High Court went to the Court of Appeal that is before us, that's what's before us, is a challenge that could have resulted in the setting aside of the transport issued by the land court, even though there was no quote-unquote appeal, because the process did not permit an appeal because there was no objection, but the process in Guyana allows it to be challenged by way of fresh action on the basis of fraud, correct?
Yes.
So this was a fresh challenge on the basis of fraud to challenge the transport.
But I don't concede that it was a proper challenge to the land court judgment. I don't concede that.
Why not?
There is no prayer to that effect, and there are no particulars, because fraud has to be established before that.
Does the writ say fraud? Or what did the claim say?
This is what the writ. This is what the writ says. At paragraph 6.
Is the word fraud mentioned in the
Yes,
writ?
yes, definitely. Falsely and fraudulently obtain what purported to be titled to land.
I.e. the transport.
No, there's no mention of the transport, but
No,
there's
no,
a
I
description
know.
of the property.
Well, right, but,
Yes.
but listen, clearly that is saying that what you did at the land court was you fraudulently obtained title to the land. How did they get title? By way of the transport. Agreed?
Yes, but there are two layers to this, Your Honor. And this is the way I believe that the land court judge resolved the matter.
No, wait, we're not there as
Yeah.
yet. We're on the question, limited to the question, whether or not the action filed in the High Court constituted in law and in fact, consequentially constituted a challenge to the transport issued by the land court.
I'd say submit it did not.
So
squarely
what
challenge
was it trying to do?
Because there was no, to set aside that transport, Your Honor, in addition to simply saying that it was obtained fraudulently, there had to be particulars, one, and two, there had to be a prayer to that effect, to set aside the
So
transport.
in the statement of claim, in the statement of the case,
Yeah, there was nothing like that.
there's no mention of the word fraud?
There is, but there are no
is.
particulars.
There is, and there's also this, there are two claims here, that it was fraudulent, null and void, of no effect, and so on. I mean, you've pointed out that it doesn't match the writ in paragraph 13B that you pointed out, but there's also 13F that speaks to any other relief.
Yeah, I see that relief, Your Honor, but that does not raise a direct challenge to the order of court. I mean, we cannot set aside an order of court by in a side win like that. But the point I want to make, Your Honor, assuming, this is what I think the trial judge said, assuming that, I don't concede, but assuming that the land court's decision was obtained by fraud, and assuming that there was particulars and evidence to support such a finding, assuming further that there was an express prayer to set aside that land court order and the transport which resulted.
Deficiencies in the pleadings.
Yes.
If the pleadings were properly formulated, if the particulars that Mr. Hootie stood up and spoke to us about, suppose those were in there, on the evidence, your position is there has been no proof of fraud and therefore no basis to interfere.
Yeah.
But, hold on. Is it correct, therefore, that before this court, those findings of facts are being challenged? In other words, the argument of Mr. Hootie, forget about the amendment point for now. The argument before us is, hold on, The trial judge got the facts wrong. The Court of Appeal got the facts wrong. And you, this court, you need to look at these facts because the facts speak to fraud. I want to amend to line up the ducks. But forget about the lining up for a moment. On the facts, his case is the trial court wrong. Suppose he persuades us of that. I'm just asking, go along with me for a moment. Suppose he persuades us that the trial judge and the Court of Appeal got it wrong on the facts. What are we to do with the transport?
Persaud's transport.
Yes, Persaud's transport. Suppose they got it wrong in concluding that there was no fraud proven.
Well, if Your Honor, I understand where you're going. If there is fraud on the part of Persaud, of occasions that we need to particularize fraud. There is no allegation of fraud against Persaud in these proceedings. I'm not yet at particulars. There is no allegation of fraud against Persaud.
But the allegation is there is fraud. Can anything stand on fraud?
Well,
But just clarify that, there's no pleading of fraud, you mean?
yes.
Because, I mean, there's evidence and there were these suggestions and that, you know, he saw the land and so on and so forth. So there were suggestions against him.
Yes. There was those suggestions in cross-examination. Of course, the trial judge did not accept. I think, Your Honors, will see.
No, we're not for the moment. We're not on whether the trial judge accepted. We're just trying to get the theory of the thing right for now.
Right.
So that on the evidence, there were attempts to allege that Persaud had noticed there were irregularities, i.e. that there was fraud involved. That is what the case was about before the trial judge. The trial judge rejects it, we understand that.
Yes.
But that was the case, wasn't it?
That was put to him in
Yes.
So,
So-
those suggestions.
Yes, so that if they were successful,
Yes, Your Honor, that's what I conceded. If.
Right.
Mr. Estrich,
Yes, please.
the nature of the title of the Estrich, can we come back to that again?
Challenge.
Really?
In
Where?
the sense that, well, the only challenge, the only issue is the paragraph 6 of the statement of claim.
Right.
That the first name, which is George Estrich, falsely and fraudulently obtained what purported to be title, but there's no
Now,
relief.
the issue of the title by the land court to the Estrich, was that ever challenged?
No, there was no direct challenge
So
to it.
what this contains, what this implicates, paragraph 6, is not, to my mind, any choice of possibilities arise here. What I want to see, what I need to see for anybody to say that a judicial determination as to the status of a thing is now impeached and is being voided and made a nullity because it was obtained by fraud. Is there not a need for that to be directly and specifically asserted?
Yes, please, Your Honor.
Okay,
There
thank
needs
you.
to be a direct challenge to it. The fraud that was committed on that court needs to be specified, and there must be. In the last sentence of that paragraph, she says this, Her Honor says this. It was then urged that, quote, Persaud knew or ought to have known of the deception and fraud committed on the land court and the estate of Albert Vigilance. And she concluded there was no evidence to support this submission. There was no evidence. And the evidence, as she pointed out earlier, is an allegation that the regular process wasn't followed by Persaud in obtaining his transport, which was rejected by the trial judge. She relied on the evidence of the registrar and so on. But still, as Your Honor, the President is saying, there was no real challenge or direct challenge to the order made by the land court judge and as to why it was fraudulent. But at the end of the day, the way I understand the approach taken by the trial judge is that even if the Estrich or George Estrich had committed a fraud on the land court, there is no evidence, no allegation that Roopnarine Persaud obtained his transport by fraud.
Original route of type, that original was, let's just say if you're not accepting it.
Yes.
Assuming it was fraudulently obtained, doesn't it taint the title obtained by?
I don't think so, Your Honor, because what Section 22 requires is proof of fraud or privy to fraud on the part of the holder of the transport. So if, as the trial judge concluded, Persaud was innocent, there is no basis under Section 22 for setting aside his transport. Because the irregularities, I understand what Mr. Hussi's submission to be, that there were these irregularities, because it doesn't rise, there is no fraud, no finding of fraud. He concedes that there are no particulars of fraud against Persaud. But he's saying that there were these irregularities, which were addressed by the judge, that can serve as the basis for setting aside the transport. And irregularities, as Your Honor known, as the Court of Appeals said, are generally curable. And non-compliance with procedural rules.
But hold on, but the law requires proof of or privy to fraud.
Fraud, yes.
Under this section.
Yes, please.
So unless the irregularities can lead...
Rises to the level of fraud.
Or, yes, well, leads to a conclusion, because it could be proof of or privy.
Yes.
So proof of and then knowledge of, privy to, right? Or participating in, right?
Yes, please.
So that even if we were to accept that there were irregularities,
Yes.
here were missing pages and so on. And
Yes.
I think that's all accepted. The registrar says, well, okay, this is because of the state affairs and so on. A court was compelled under this legislation to have to reach a determination.
Request when it came to the amendments, as I started off by pointing out, that there were three things that were requested to be put into evidence. The missing compliance, rates and taxes receipts, and the third one is the transports of the plots that were sold. Those things don't amount to fraud, Your Honor, even if they were put in, even if the amendment was granted, assuming that they had a right to the amendment, and the trial judge improperly exercised her discretion, and those pieces of evidence were put in. They don't prove fraud, and they don't prove fraud on the part of Persaud. They don't.
Mr. Satram, Mr. Husti alleges or submits paragraph 14 of his submissions that in the absence of fraud, it was open to the Court of Appeal to consider whether the irregularities and defects in the declaration of title proceedings, so going back to the first set of proceedings, from which the title of the respondent emanated was such as to render same a nullity. And he claims that courts have set aside transport on the ground of nullity and cites Hiralal and Shiv Charan, and a more recent case from this court, Singh and Singh. But you're saying you dispute this.
No, because then Your Honors will be relying on a rule which is not provided for under the Deed Registry Act. The Deed Registry Act is clear. Section 22. Yeah, but Your Honor, there's also Section 23. Section 23 provides for the correction or amendment of transports where there's misdescription, errors, and omissions. In my submission, 22 and 23 provide a complete code upon which a transport can be amended, revoked, annulled, canceled, and so on. 22 deals with fraud, and fraud alone, and 23 deals with errors and omissions. I didn't get that, Your Honor.
The effect of these cases that he
Well,
cites?
most of those cases, and there are quite a few more, all of them, outside of fraud, they've dealt with cases where there was misdescription. And the court was really acting under Section 23 of the Deeds Registry Act. Because if, yeah.
None of those cases are they setting aside. They are
For
correcting the
irregularity.
record.
No.
They are correcting the record.
Correcting the record for errors or omissions. Because, for example, if I intended to obtain title to Lot 13 Henry Street, and by some mistake, my title says Lot 14. There's no fraud there. That is a simple error or omission. There's innocence. And in that case, the court is empowered under 23 to correct it.
Right, so in some counsel, you're saying that none of the irregularities which have been raised by the appellants
Among the
would
fraud.
bring the case within the scope of Section 22?
Yeah, I'm saying yes, Your Honor, but I'm saying that to a rule which provides that irregularities, which we know are normally curable, any irregularity or irregularities generally can render a transport void, is dangerously wide. In our submission for an irregularity, per se, to be relied on to render a transport void or null, it has to rise to the level of fraud. There must be fraud. Otherwise, it creates uncertainty because under 22, there's a limitation period of 1 year for fraud. What would be the limitation period for irregularity if we rely on that as a ground for setting aside the transport?
But in any event, the whole point of the transport system is to bring certainty
Exactly,
and
yeah.
indefeasibility of title subject to the statutory.
Yes,
And that's why even fraud, which generally has no limitation, is limited because they want to bring certainty to title for the benefit of land transactions. So
Yes.
I think we understand how that system operates.
Well, Your Honors, this court has pronounced on the need for certainty in land ownership on many of the cases. Because it will create a whole new set of uncertainties if we say irregularity. What kind of irregularities? Those that can be cured? Must it be irregularity that people have notice of? And what extent must we investigate? Must potential purchasers investigate these irregularities? Especially when there are irregularities that supposedly occurred in judicial proceedings. Judges are expected to know the rules.
Anything else? Thank you.
Thank you, Your Honor.
Mr. Houston, is there anything?
Your Honors, at this point, unless the court has any questions for me, there's nothing that I need to say in direct response. And I will come to the front if...
No.
I detected that Your Honor's invitation for me not to come there suggests that I need not say anything further. I'm guided, please, sir.
I did not get that was a nuance or a content of my inquiry.
I understand.
So if you had anything else, then I would have said, then please.
No, please, Your Honor. No, please, Your Honor. I appreciate the opportunity to do so, but I have nothing further to add. Thank you, Your Honor.
I want to commend you on your graciousness. Thank you. That being the case, I will ask the registrar to close the proceedings. Of course, we will give our decision in the fullness of time.